With effect from January 31st, 2020, the United Kingdom's withdrawal from the European Union has finally become effective. Nevertheless, the exit agreement between the EU and the UK provides for the EU regulations to continue to apply to a large extent until December 31st. At present, British nationals can therefore continue to travel to Germany at any time, like other Union citizens, for stays of up to 90 days within 180 days, and stay here for longer if they are either employed or are seriously applying for one. But what applies to newly arriving British citizens after the end of the transition period, to those who are already in Germany and have their place of residence, or who are justifying this before December 31st? At the moment, negotiations between the EU and the UK are still ongoing, and well, we'll see how that will go. But a few weeks before the end of the transition period, it's not yet clear once again whether these will be successful after they have almost failed several times. This is not a novelty either. Today I want to tell you about the effects of a failure of these negotiations and their impact on the residence and labour migration rights of British nationals who are new to Germany and want to take up employment in Germany from January 1st. With regard to entry and residence in the EU and any of its member states as of January 1st, newly arriving UK citizens would not be granted any entry and residence privileges. After the end of the transition period, they would no longer be EU citizens, Union citizens, although this as a status like German citizen, British citizen also does not exist, it's a special term, and would therefore not benefit from any of the rights previously granted to them because of their Union citizenship. Therefore, the question of whether they will be entitled to cross the border of an EU member state and stay in an EU member state would have to be regulated and considered by both EU and national laws depending on the length of stay. In principle, every third country national is required to have a visa before entering the Schengen area, and that includes Germany under EU law and national law. However, the EU regulation from 2018 provides for an annex listing the countries for which the visa requirements is lifted. As early as November 13th, 2018, the European Commission had already proposed to add British nationals to this appendix and also to allow them to enter the EU without a visa for short stays, but only with a proviso that the United Kingdom in return also allows all EU citizens are granted visa-free entry. Since this reciprocity seems to be guaranteed by corresponding privileges for Union citizens when entering the UK, this was also implemented from January 1st. As a result, this would mean that neither British citizens nor German citizens, like all other EU citizens, would need a visa if they were to enter the Schengen area or the United Kingdom for short stays of up to 19 days in a period of 180 days. So far, the UK is even extending that. British citizens will therefore not require a visa for visiting and/or business trips with a maximum stay of 90 days within a period of 180 days. The same applies to British citizens with the information British Overseas Territories citizen, British Overseas Citizen, British Subject, British National Overseas and British Protected Person in their passport. When crossing the border, the documents and receipts required for entry into the Schengen states must be carried with you, in particular a valid travel document as well as evidence of the purpose and circumstances of the intended stay. They also must have sufficient means of subsistence, both for the duration of the intended stay and for the return journey. This also regularly includes taking out valid and appropriate travel health insurance, whereby the possession of an EHIC card is no longer likely to be sufficient as a rule. The privilege of visa exemption to the extent mentioned applies, with a few exceptions, only as long as no gainful employment is to be carried out. If entry is not only for business or tourist purposes, but also for the purpose of intended employment, no privileges would no longer apply to newly arriving British citizens without an agreement between the EU and the UK or without corresponding national laws in the member states. So far, British nationals continue to enjoy the full so-called free movement of workers. This includes the right of employees to apply for jobs actually offered in other member states, to reside there for this purpose, and also to pursue employment and to stay to a certain extent even after that's ended. All these privileges would be over by the end of the year. British nationals entering the country would then be treated on an equal footing with non-privileged third countries nationals such as Indians and Chinese. First of all, to counteract a common misunderstanding, it should be pointed out that if you are able to enter the country for short stays of up to 90 days within 180 days, you are generally not allowed to take up employment. Only activities that do not constitute taking up employment are permitted, regardless of whether it is self-employed or dependent employment. The following activities, among others, are permitted: participation in meetings, conduct negotiations, purchase of goods, and the conclusion of contracts with German business partners. In the case of activities going beyond this, according to the general definition of an employee, the decisive factor is whether an externally determined activity is performed for somebody else, in which one essentially cannot freely dispose of the time and place of the activity. If this is the case, a residence permit is required to take up employment, regardless of how long the employment, and that means from the moment you take up employment. Otherwise, there is illegal employment that constitutes an administrative offensive and can result in a fine of up to 5,000 euros for the employee or 30,000 to 500,000 euros for the employer. Of course, this also applies to the British. Incidentally, third country nationals are only allowed to take up gainful employment if one of the few exceptions provided for in the employment ordinance applies. There it is provided for specific purposes for short stays that these are not considered employment. With this non-employment fiction, it is practically legally faked, you can call it, that the exercise of the activity is not an employment. This applies among others for the following activities: activities as a manager, executive employee, or as a business traveler for up to 90 days within a period of 180 days, certain activities including interns and further training courses for up to 90 days within a period of 12 months. Activities in the context of the provision of services by foreigners who have the status of long-term resident in another member state of the European Union of up to 90 days within a period of 12 months. Activities of certain persons who are exempt from the requirement of a residence permit are: with regard to business travelers, it should also be noted that the exception does not apply in general, but only to certain types of business travel, namely to people who are employed abroad in the commercial sector for an employer based in Germany, or conduct meetings or negotiations in Germany for an employer based abroad and prepare contract office, or to conclude contracts or monitor the implementation of a contract, or establish, monitor or control a domestic part of the company for an employer based abroad. And this applies to all three case groups who do not stay in Germany for more than 90 days within a period of 180 days in the course of their employment while maintaining their habitual residence abroad. If the requirements of these exceptions are met, this means for foreigners who can enter the country without a visa that they do not need a residence permit to work within the specified time and content limits. With regard to long-term stays, explicit rules are required in order to prevent newly arriving British nationals from reverting to the level of non-privileged nationals from January 1st. To regulate this falls within the sole competence of the Federal Republic of Germany, since the EU has no legislative power in this regard. According to the national regulations, every third country national must apply for a residence permit for those purposes of gainful employment at the German embassy or the German consulate general in their home country or country of residence. This would of course also apply in principle to British nationals from January 1st. As in most other countries, however, Germany has introduced a number of privileges in relation to some nationals. In Germany, the most privileged citizens, such as Americans, Canadians, Japanese, Australians and South Koreans, benefit from the following privileges: residence entitlement for more than 90 days if a residence permit has been applied for before the final decision has been made. Possibility of issuing a residence permit for the purpose of a gainful employment for any type of employment regardless of where the employer is based. This is intended to enable these privileged nationals to enter the country before the residence permit is issued, including for longer term stays, and to carry out the procedure in Germany. If you apply for a residence permit in good time before 90 days have elapsed, you will be issued with a fictional certificate on the basis of which further residence is deemed to be permitted. However, the intended employment may only be taken up after the residence permit has been issued. According to the legislature, these privileges will now also be granted to British nationals from January 1st. This is to be regulated by the second regulation amending the employment regulation and the residence regulation. According to its explanatory memorandum, the aim of this draft is to give nationals of the United Kingdom, of Great Britain and Northern Ireland, who are not covered by the withdrawal agreement, easier access to the labour market. This privilege is intended to take into account Germany's diverse trade and economic relationship with the United Kingdom, of Great Britain and Northern Ireland. But don't forget, what I'm saying now only applies to Germany, because this is a national competence, not an EU one. Without the regulation, nationals of the UK who are not covered by the withdrawal agreement usually have to prove a qualification as a skilled worker in order to be granted a residence permit for employment, and thus a domestic or recognized equivalent foreign qualification. Nationals of the UK would therefore have the same access to the labour market as nationals of other major trading partners such as the USA, Japan, Australia or Canada. The Federal Employment Agency could then approve any employment regardless of the formal professional qualification and the seat of the employer, but would of course check the equivalence of the employment conditions as part of the priority check. As long as the negotiations between the EU and the United Kingdom are still ongoing, there is still no clarity about the regulations that will apply to new British nationals from January 1st. Should the Federal Council approve the draft ordinance in its last session, which is likely to be the case, this would ensure equal treatment of British nationals with nationals of the most important trading partners outside the EU, at least in terms of residence and labour migration law. And rightly so, given the decades of partnership. And if you want to stay informed, please subscribe to my channel, subscribe to my newest 2 channels as well. I'll see you in my next video. Bis gleich.